All right, we are live. So, hello everyone, and welcome to Family Law Fridays presented by Florida Women's Law Group. I'm Jadlyn Fleischer, legal intern here at Florida Women's Law Group. Family Law Fridays is designed to be a resource for all women with any type of family law issue. Today, we'll be clarifying mediation and mediators. Before we get started, I'd like to give you some information about our host. Our host is Heather Quick, founder and CEO of Florida Women's Law Group, which is a family law firm that advocates for women in North Florida. The firm educates and empowers women on their rights and the law so that they can find the strength to endure the process and end up better financially and emotionally. Heather Quick has been a licensed Florida attorney for the past 20 years, with the majority of her practice over the years being in family law. Please join me in welcoming Heather Quick to Family Law Fridays.
Thank you so much, JD, and welcome to everyone who has joined us today. And we're talking about something that I've certainly had videos on before, and we always have a lot of questions because the topic of mediation comes up. So I'm going to break it down for you just to give you a clear understanding of what mediation means within a divorce and family law issue, and how to prepare for it and what to expect. Because I think there's a lot of misconceptions out there, and there's a lot, frankly, of misinformation out there on various sites, and it's best to understand what, one, the process is intended for, and two, how it best works, how to get the best results for yourself. So in Florida, when you're dealing with a divorce or a post-divorce issue or paternity, mediation is required. So let's talk about what is mediation, because sometimes folks will come to me, I'll talk to many women, and they'll say, we just want to mediate. And that is, of course, a good thing, but you don't just mediate without all the proper information. And so let's discuss what mediation is. Now, they're certified by the Florida Supreme Court mediators in the state of Florida. Now, presently, they're mostly going to be lawyers. Sometimes I've had former judges who became mediators. There's a lot of different types of individuals who then go into that. And it is important to understand their background coming into mediation, because it's something that, in my opinion, in my experience, you want to be successful. So you want to prepare yourself for success, right? I mean, that's how we are successful at an endeavor, is go into it with all of the tools, proper preparation, so that you can equip yourself to make a good decision. So the mediators, they take courses, and in mediation, there are rules that govern mediation. And this is important, and I will come back to that in a little bit, because that's very important that you understand the role of a mediator, which is a very important role, and it's truly a very successful process. And even some of the cases that you think are very difficult aren't always impasse. They don't always have to go to trial with the right mediator. So there's the rules that govern mediation. And just because the mediator is a lawyer, which they are, and that's important, the best mediators have practiced as family law litigators prior to going into mediation. In my opinion, they have experience. They understand what can't happen in a trial. They are very aware of current case law. They are aware of what could likely happen if you go to trial. Now, because you want to hear that, you should have, and hopefully you know that information from your lawyer. Always important. Your lawyer should always be telling you best case, worst case, in their experience, where you might likely end up. But maybe you hear it differently when it comes from a mediator. or they express to you something they've learned from the other side. So that's why I prefer mediators who have litigated in the family law arena, so that they are, and who stay current on the law and the cases and trends that are happening, so that so we're not educating them during the process. Often that can happen in a courtroom. And so when you have the opportunity to not have to do that in a mediation, I think that's better for all clients involved. So we've talked about that there are rules, and then let's talk about when mediation occurs. So there are the statutes in Florida that direct, prior to going to trial, you must mediate. Now, so that means if it's an original divorce, or if you're modifying a divorce, it's an original paternity or a modification, you will then be ordered to mediation. Sometimes cases are maybe just a variety of motions and a lot of issues to be determined. The judge has the power to order you to mediation, and your attorney will go through that with you. We typically, we can tell you based on what judge you're going to be in front of and what issues there are. If in our experience we think, hey, the judge may order us to mediation, and or two, mediation may really be in your best interest. So maybe we should propose that we go through to mediation. And let's talk about that. Mediation, basically it's compromise. If it hurts a little on each side, that's probably a compromise. We're not going to mediation and going to get your best day in court, which, the odds of that are low. But you're also not going to settle for your worst day in court, because again, the odds of that are low. So it's a meeting in the middle, and it is, when successful and done well, it's an amazing process that, as I indicated prior at the very beginning when I was introducing the subject, cases that have a lot of animosity, a lot of history and resentment and just difficult issues to overcome, they can be resolved in mediation. And it is surprising at many times that case settles. And likewise, sometimes we think a case, oh, this is rather straightforward, but it doesn't settle in mediation. So it, of course, because we're humans, and the individuals going through the divorce are humans who have a lot of emotion, a lot of history, and sometimes it's not possible on that day to settle. So when we look at when to go to mediation, because that is something that I find to be very important, and important for your case. And you should definitely be discussing that with your attorney. When is this case right for mediation? I have been in cases previously that it was too early. We didn't have the financial information. We didn't have everything that we needed to completely settle the case, and it didn't work. And that I realized at that point that the timing is important, as with many things. And timing being one, you've had the information, but maybe there's been some part of the litigation you've been through, some issues that you've dealt with that make either you or your husband in the right mindset and have enough information. It's time to settle. So that's not always a prescribed amount of time. I wish I could tell you that. It's not. Think about this. If you were blindsided, just from the standpoint of you didn't know the divorce was happening, and you got served, let's say May 1st, because we're talking about May, and by May 15th, let's just say, you and your attorney had absolutely all the financial information, every bit of evidence, information that would be needed to settle the case. I got to tell you, emotionally, you may not be ready. You might need a little more time, but maybe you are. But if you emotionally aren't ready, that is an expense to go to mediation, the time the mediator's getting paid, the lawyers, the it's draining. It's an intense day as far as being on and discussing a lot of issues that are your life. So timing is very important, and don't underestimate that. And it's not that it's, like I said, a prescribed amount, but trust the process and your attorney to help you understand when they think it's right. Because we know what the issues are, and we will outline for you all the issues that need to be decided. And you will have a clear understanding going into mediation. These are all the issues that we need to resolve. Pros, cons on each side, risks, benefits of everything. And then, everybody should have a wish list. Hey, this is where I would want to be. Because sometimes there are things that a judge is not going to address, whether, it's legally he can. We can be very creative in mediation. Or it's an issue that probably the judge is not going to make a ruling on. But mediation is the time to get creative and throw it all in there and let's go through everything. And you don't want to forget anything. You don't want to leave out those hotel points, those airline points, those fringe benefits, club memberships, and what have you. There's so many things. Want to make sure you have a comprehensive list of the assets and the debts. So that's where timing is very important. Now, let's talk about those who, you've come to me and you said, yeah, well, we're going to mediate. That's what my husband wants to do. He just wants us to go to mediation. And you are trying to be reasonable and appease him so that he doesn't get upset, and are thinking, okay, we're going to go to mediation. And you're going to come talk to me as a consult, and I'm going to tell you, don't go to mediation unrepresented. Because if you have any assets or debts or children, you are rolling the dice and you are not being advised. The mediator, by the rules that we talked about, they cannot advise you. They cannot provide you legal advice. Legal advice is taking your facts and the law and saying, this is what I would do in this situation. They cannot do it. And if they do, they would be disbarred. They'd be sanctioned. It's terrible. Mediators don't do that. They are not going to tell you how that this is good legal advice. So you're going in there on your own, and you don't know what you're entitled to. You don't know what could possibly happen in court or not. So then how can you make a good decision? Our best decisions are one based on preparation and full disclosure. If you don't have full disclosure of the financial situation and how it will impact you, the greater the finances, the more implications there are for taxes and different investments, and how long it's going to last you. If you've really had someone who's objective look and advise you and tell you, you may be thinking, oh, this is great. And, when you tell me your settlement, I'll say, well, that was your worst day in court. You left all of this on the table and you didn't even know. It's one thing to be fully aware and walk away. I don't have a problem with that. We all do what we need to do to preserve our sanity, to make decisions based on where we are at the time. And that happens. But if you don't even know what you're walking away from, I would say that is not wise. You are risking that of your future based on what you put into the marriage, and it won't come back. Once we distribute the assets and the property division within a divorce, you can't change it. Alimony can be, depending, but more likely than not, your husband, if he's savvy, he's done his homework, he's suggesting mediation to you so that neither one of you spend money on attorney's fees. He probably has a really good idea of where what he's going to do, and then he makes it the alimony non-modifiable. Maybe he doesn't even put in there child support. Hide assets, doesn't even let you really understand where everything is. And that can't be changed. So any business transaction that you would go into, which is basically what we're talking about, it's a dissolution of a business, but when we're talking finances, that's what we're doing. And if you are not the savvy financial person in the marriage, usually one is more than the other, frankly, then you need representation. So what does the attorney do for you? What does your attorney do for you in mediation? Because some individuals truly are just saying, well, I could do that part myself, and if it doesn't work, then I'll hire an attorney. And again, that is, you're at a disadvantage from the standpoint of the time. One, the time you've lost your life, because then you're going to, have to prolong the process, and cost of the mediator and the emotional expense. You are hiring an attorney to protect you from yourself, as well as from your spouse, to not make decisions based on your ego, based on a short-sightedness, out of revenge, out of sadness, out of being trying to be a pleaser and appease the other person, while you end up on financial aid or food stamps after the divorce. And trust me, it can happen. And your husband isn't going to be feeling bad. He is going to claim victory that he really, snookered you out of what you were entitled to. So don't be dumb, all right? Be smart. Because if you think for 1 minute, and when we're dealing with money and children, and your husband's saying we're going to do it this way, that he has your best interest at heart. And that is my opinion, based on my experience and based on years of seeing this happen. So you want someone who has your best interest at heart. And frankly, mediators who are great people, they don't have your best interest at heart either. Not over your husband's. They don't know you. They're helping you both compromise. They're not bringing new information to the table, and they're not really asking you if you know all of the information, or telling you that, this could happen in court or this could happen in court. They're not advising you legally on how that might be interpreted, or different cases. And they're not going to tell you, you should not take this deal. They're not going to. Because that would be legal advice, and they would have issues ethically. So you're going to think they're the nicest person in the world, and they are, but they're not your advocate. Do you have an advocate in the process? Because that's what you should have. Everyone should have that. And everyone should know the difference, because that happens a lot. And you have this belief that you're entering this process and you're doing it the right way, but you're misinformed because you're not prepared. And it's not your fault, but you don't practice law, don't practice family law. And even if you do both of those things, do you really have objectivity on your own case to have someone, one, protect your interest, advocate for you, and advise you, and hopefully be the sound voice of reason, and the voice of reason on both sides? When, I have had clients and I said, no, don't take this deal. I have litigated enough of these cases. You are going to get alimony. This is a marathon, not a sprint. Hold out. They're just not, that's not a deal that you can accept. And we have prevailed. And at trial, and received alimony far greater than probably what we even offered or had been willing to accept. But then all bets are off. We're going to trial, then you go. Everybody has an opportunity at mediation to compromise, but anyone who goes in there and is just like, I want it all, it's not going to work. And if you settle and your husband wants it all, then you've been, really taken advantage of, played a fool, but you participated in that. If you're fortunate enough to hear this now, and believe it, if you believe the spouse that is divorcing you that you should not have an attorney, just question their motives, because what I'm telling you is everyone going through a divorce should have an attorney, whether it's our firm or someone else. You need an advocate, and I just don't agree with that premise whatsoever. Protect yourself and your money and your future. The mediator's role, and this is really important, is to be a neutral, but to bring the parties together. And it's an interesting process. I don't go back and forth from one room to another, but I've done enough of it that I know the mediator sometimes will push you in the mediation. Now, obviously, if you're there by yourself in a pro se, I don't know how they handle that because, you know, they're following their rules. They will push you to compromise, but I'm sure it's a bit more reserved because when our attorneys are there, we're here to kind of protect you and say, hey, cool off. I'm going to talk to them about this particular issue, and then you can come back. And then they go to the other side and they do the exact same thing, because the only way we're going to compromise is if somebody is, one, helping you see a different point of view, and also reminding you of the big picture and getting everybody. And it doesn't happen where everybody goes in and says, this is what I want, that's what I want, and boom, you're done. It can. But a lot of times it does take time, because we tackle one issue at a time and everybody's got to do a back and forth negotiation to get to the right spot. And that is something that allows you to have closure to your divorce and to have had input in the process. And most of all, to have been informed and to know. Because during your pre-mediation strategy session, your attorney's going to tell you, I mean, what we do anyway, we have a pre-mediation strategy session. We're going to let you know, like, hey, this is everything we got to figure out. I will tell you what I think, not that I know, no guarantee, how it would end up with the judge, usually with a range, so that you can compare that to what decisions you make. And then you need to know what's important to you. Hey, is this, you know, cash account important to me, or is this house or this piece of property, this piece of jewelry? You know, what assets are most important to you and what are going to help you the most? You don't want to be house poor, say I have to have this house, but then you can't pay for it. Do you know what amount of alimony you need, and for how long, and how that is filters in with everything else? If there are minor children, if there are debts to be paid, or there are other properties that are investment properties or investment accounts. Those are all things that have to be decided. And you know, if you have accounts for the children, how are those going to be decided and determined? So there is a lot, you know, you'll have that comprehensive list. You'll have, you know, a spreadsheet that lists all the values of everything, because many times evaluation of certain assets is just as important as anything else, because we must look at their value. And if we can't agree, we're going to have to get over that hump in mediation. And that's why I said discovery, all of those documents are so important, because if we don't have an agreed upon value, it prohibits sometimes a lot of settlement, because at the end of the day, we're looking, is it going to be equal? That's what the judge is going to do. Now, sometimes we may settle and one side gets more than the other on the bottom line, but you got something that you wanted that you couldn't get otherwise. And that also happens. And a lot of times it's a different kind of alimony, or a different kind of payout of a business, or using an extra fund rather than alimony, switching off property. There can be so many things, but without a full understanding of your entire estate, from the assets and the debts, those debts are really important. They must be addressed in the divorce, because if they're not, then you're both still on the hook, and that leads to further litigation. The best divorces, and it doesn't always happen, we always strive to really create an agreement that doesn't require you going back in court. If someone advises you, well, don't worry, you can go back in court and change that. It's not, I'm just going to tell you that's a lie, because there's never a guarantee. Usually many things have to fall into place to allow you that opportunity. But regardless, you're going to have to go hire an attorney and go through the entire process again. You should never sign an agreement thinking, I'm going to go back in 2 years and change it. I advise you not to do that, because you're not thinking long-term. This is a long-term situation when we're dealing with a divorce, because your future's involved. Even if you don't have small children and it's alimony, you're thinking you'll go back. But if you do have small children, there still may be disagreements in the future, but you certainly don't want to plan on it or be settling something with a belief that the facts are going to align, the law is going to align, and you're going to be able to make the change in the future. Because that's just a bad strategy. It's not a strategy. It's just like thinking you can get a do-over or upgrade it later, and it just doesn't happen that often. Sometimes it does. I'm not going to tell you it's always, but it's going to be costly. Modifying agreements and changing things sometimes are more expensive than the original divorce, depending on the things that were agreed to, what the issues are. And, that can be very frustrating for individuals. So I'm letting you know ahead of time. I mean, why do this twice? Do it right the first time with all contingencies, all ideas addressed in that mediated agreement. And so based on all of that, that's why, one, you need a lawyer on your side to help you see all of that. Because if you think you're saving, money now, it just depends on what you agree to. And of course, I see all the cases where it goes wrong, or they're upset and they regret what they did, and I, can't fix it. We can do a lot, but some of those agreements just cannot be changed. And so you're looking for a short-term band-aid to not upset your husband at your expense. So you're martyring yourself, and you're going to get stronger the longer you're divorced, and then you're going to be in an attorney's office 6 months to a year, like, you know what, I don't like this agreement anymore. This is really, I did this to get out quickly, but now I want to do something different. Many things we can't do. So along those lines, I hope this is helpful, because I really believe that all women should be represented and have an advocate for them during the divorce process, because everyone shows up to it differently, and you may not be as strong as you once were, and you may just need that person who can really guide you through. And if you aren't if you're not practicing, divorce law in Florida, you don't understand the law as you understand whatever business that you've been in, or taking care of the home, helping your husband with this business, whatever you've been doing, or you're a practicing physician. I would not begin to advise you on, your proper technique for whatever, surgery, prescriptions. I haven't gone to school. I can read a Google article all day and I can read something, but I'm not going to do it myself. And it's the same theory for women going through a divorce. You should have someone on your side, protecting you from your spouse, from yourself, from bad decisions. And at least as sitting there to say, hey, do you recognize what you're doing? And are you aware of of the decision and the choices you are making, so that you don't regret it? And that's all it is. Don't regret it in 3 years and say, I wish I had done this. I should have found this out, or this, those are the types of things that keep you up at night, versus going through this process and finishing and then having peace and going on with your life. That closure and just knowing, hey, I handled it in the best way that I could. I stood up for myself, and I'm able to walk away, hold my head high, and I'm not going to regret the decisions, the compromises I made. Because if you're able to come to a compromise, there are going to be some things that your family may question, your friends. But if you've prepared yourself with all of the evidence and the preparation of the financials and your risks benefit analysis, you're going to be comfortable with it. And that's what counts. So I thank you so much for your time today. If you have questions about the divorce process or the post-divorce process in Florida, and how mediation really is in reality, which is a lot like what I said, and you question whether or not you should go to mediation, please call our office, schedule an appointment, and you will meet with our well-trained family law attorneys, our client liaison, and really understand your situation and understand how to make a decision to change that. So thank you all for joining us today, and look forward to hearing from you in the future.
Yep, so thank you everyone who's able to listen in today for Family Law Fridays. As always, if there is a topic you would like addressed or a question you would like to be answered in an upcoming video, please call, email, or send us a Facebook message. It could definitely be addressed. We're available by phone at 904-241-0012. We hope you found the information today helpful. Thank you, and see you next time.